Good day everyone, I am Michael, the moderator for this webinar. I welcome everyone for today's webinar, which is Complying with OCR Section 1557, Discrimination, Interpreters. I would now like to introduce our presenter for today, Laura A. Dixon. Laura A. Dixon, BSJDRN, CPHRM, Scopics, Director of Facility Patient Safety and Risk Management and Operations from 2014 to 2020. Ms. Dixon has over 20 years of clinical experience in acute care facilities including critical care, coronary care, perioperative services, and pain management.
Okay, thank you very much, Michael, for that very nice introduction. And welcome, everyone, depending on which side of the U.S. you are on. It's either good morning or good afternoon. As Michael mentioned, our topic today is a very interesting one, and that talks about non-discrimination and how the Affordable Care Act plays into that. Well, again, just a brief history of the Affordable Care Act. Now, essentially, it's Section 1557. Is what it is, of the Affordable Care Act. And that section prohibits any, whether it's a health program, a hospital, a physician, whatever it is, anyone that receives federal funds or is in a federally administered program from engaging in discrimination. We have Title VI that talks about national origin, race, color, etc. Then Title IX, where it actually talks about education, that brought into sex. Now, this is a focus of a whole bunch of litigation, especially recently. There's also age discrimination and disability discrimination under the Rehab Act. Penalties, they do come up as far as like a violation of Title VI. You can lose your federal funding completely. You can be actually disbarred, prevented from working with the government. And then there's also the OIG, the False Claims Act. So Health and Human Services came back and they updated it back in June of 2020. Now this was following a Supreme Court ruling that upheld Title VII that, hey, we can't discriminate based upon sexual orientation or gender identity. That's the Babcock ruling from Texas. Well, that wasn't the end of it, unfortunately. In January of 21, District Court came back and said, yeah, we don't like that definition on the basis of sex. And again, we're still not done. March of 22, HHS put out a statement that says, you know what, we're going to continue to protect certain individuals, transgender youth, and their families. So here we are right now. In April of 23, HHS reissued another statement supporting gender-affirming care. In July, also of 23, they issued a proposed rule to advance non-discrimination in the programs for the LGBTQI plus community. And I have the link there for that proposed rule. So as of right now, there is a new rule, two rules actually. One, basis of disability. It will go into effect in about 2 weeks, July 8th. It is 275 pages long. It talks about multiple issues that talk about what is the definition of disability. It talks medical futility as it relates to when you have a disabled patient or one that comes in with multiple disabilities. And it talks about the requirement to have certain medical equipment available for the care and treatment of patients who pose certain requirements. They changed the definition and expanded the definition of disability. The physical or mental impairment that limits one or more life activities, or a record of such impairment, or being regarded as having such an impairment. So here are some of the highlights from that rule. Again, 275 pages long. I've picked out the highlights. They changed the term from handicap to now persons with disability. You must change all the signs. They talked about a qualified interpreter. Then there's another rule that went into effect just yesterday, June 25th. This prohibits the use or disclosure of information by a healthcare provider, a plan or a clearinghouse, and a business associate for the purpose of another entity conducting a criminal, civil, or administrative action in order to impose liability, whether it's civil, criminal, or administratively. It also prohibits, again, releasing that information to conduct an investigation. Part of this new rule requires an attestation. You have to have an attestation that they sign that the use or disclosure is not for any prohibited use. So just a couple additional elements. You do have to revise your notice of privacy practices. As far as disclosures to law enforcement, it permits but doesn't require disclosure. So that's part of the Affordable Care Act, talks about non-discrimination, and that prohibits, again, discrimination based upon those protected classes as it applies to health programs, activities. It is the first federal law that really broadly protected sex discrimination. It extends protections to those who participate in those programs like Medicare and Medicaid. That's a big one. It can also be any health credits that they might receive. It covers care provided by hospitals, doctors, rehab, SNFs, health clinics. But surprisingly, it doesn't apply to the actual insurance companies. As far as sex discrimination, that includes pregnancy and the related conditions, may include termination based, again, upon what your state law allows. So in a way, I know it mentions at the beginning health insurance companies are not covered, but those who offer Medicaid Advantage are covered by this rule. Now, as far as the new rule, again, it went into effect. You're held to the same non-discrimination standards of anyone else. That includes Part B, not just Part A, it's Part B payments too. And you have to proactively let your patients know, first off, language assistance is available at no cost, and other accessibility services at no cost. Think your sign language. Telehealth, they have to be accessible to those who have limited English proficiency and disabilities, and it prohibits discrimination based upon sex. Now I want to take some time with sex discrimination and gender identity. That includes any discrimination based upon their individual sex, and that includes pregnancy and related discrimination. They included those definitions. This is in the actual rule. Identity, that's the individual's internal sense of their gender. Now let's move on to another protected class, race, color, age, and national origin. You, again, as a covered entity, hospital, office, you cannot discriminate based upon those classes. Age discrimination, you can't deny limit benefits based upon a patient's age unless you have a distinction authorized by law. On your interpreters, here we're going to talk limited English proficiencies and also those who have a disability. They use these taglines. These taglines, what you have to do, as far as the top taglines, I have the link there for you. Interpreters, let's go right to the person who's going to be doing this. They must be qualified. Now you can have certified translators if that's what you want. CMS, Health and Human Services, OCR does not require it. They only require qualified translators. You can use video interpreting services. CMS says that's fine. So what's the difference between an interpreter and a translator? Interpreter, that's your oral language. Translator is your written. They put that into another language. American Translator Association, they help advance interpretation and translation. It's a certification program. Now, one other thing I want to bring up is the Language Access Plan. Again, this was back in 2023. 68 million people in the U.S. speak another language at home, 22% almost. Only 8% speak it well. This meets the definition of limited English proficiency. They don't have English as their preferred language. AHRQ, those of you who are familiar with it, great resource. They have hospital guidelines. It talks about the role of language barriers and impact on bad outcomes or adverse events. Now, as far as the person with a disability, it really is, the plan does focus primarily on those with limited English proficiency, but it really covers those with disabilities because we know that we don't sometimes have effective communication because of that disability. And now that is a requirement for effective communication to include those with disability not only under Section 1557, but the Americans with Disabilities Act. The overall goal is what they're trying to do is ensure access for those who have disabilities or limited English proficiency. Now, the next section that we want to talk about is grievances and complaints and your compliance coordinator. This is under, again, the patient rights section within the conditions of participation. You are encouraged to have a language access plan as part of your policy, but you must have a grievance procedure That's a requirement. So the patient has to file their grievance within 180 days if it's a discrimination act. The OCR, there is a portal that's online so they can file it. So I want to talk about some training for you and your staff. They have training material to help you be compliant. So to participate, again, you as a hospital, you have to agree to follow these rights. That's the civil rights. And that includes age discrimination, the Affordable Care Act, and the Rehab Act. Now, CMS did note there were no prohibitions in the conditions on gender identities. Some LGBT patients said they've been denied care or given inadequate care. And with that, Michael, I have nothing further to add. I will turn it back to you to close us out. Again, thank you everyone for attending. Michael, thank you for your assistance.
Once again, thank you, Laura, for the great presentations. So that does conclude the session for today. Thank you everyone for participating. You may all disconnect now. Have a great day ahead. Bye-bye.